Dr. Pranjal Kumar Fukan sir. Sir, please unmute yourself. Dr. Pranjal Kumar Fukan sir. Dr. Pranjal Kumar Fukan sir. Dr. Azizul Haq sir, can you hear me? Please unmute yourself.
Yes, yes, I'm hearing you.
Okay, okay, thank you so much.
Okay, thank you.
Sir, can you hear me, sir? Dr. Pranjal Kumar Fukan sir. Actually, I'm not getting your voice, sir.
Hello?
Sir, if you are using earphones, sir, please disconnect the earphone. Sometimes it might be some problem. Dr. Pranjal Kumar Fukan sir. Sir, can you hear me, sir? Now?
Yes,
Okay,
yes,
sir.
Doctor. Yes, you are audible.
Okay, sir. Welcome to this platform, sir.
Welcome.
Dr. B.N. Patnaik, sir. Principal, sir, Rupahi College. Principal, sir, Rupahi College. Sir, please unmute yourself. Yes, sir. Sir, can you hear me, sir? Principal, sir, Rupahi College. Sir, if you are using earphone, sir, please disconnect the earphone. And even the problem persists, then please rejoin the meeting again after leaving it. Dr. B.N. Patnaik, sir. আপোনাৰ স্যাৰ ইয়াৰফোনটো স্যাৰ ডিসকানেক্ট কৰি লওক ডিভাইসৰ পৰা আৰু যদি তথাপিতো যদি প্ৰবলেমটো সলভ নহয় দেন আই এডভাইস ইউ কাইন্ডলি লিভ দ্য মিটিং এন্ড ৰিজইন अगेन স্যার প্লিজ প্ৰিন্সিপাল স্যাৰ কলিয়াবৰ কলেজ ডক্টৰ হিৰণ্য কুমাৰ চলিয়া স্যাৰ স্যাৰ শুনা পাইছেনে স্যাৰ
Yes.
Okay, sir. Thank you, sir. Dr. B.N. Patnaik, sir, can you hear me now? Yes, sir. Dr. B.N. Patnaik, sir. Sir, can you hear me now? Sir, if you are using earphone, Dr. B.N. Patnaik, sir, please, sir, disconnect the earphone. I think problem is with the earphone. Dr. Azizul Haq, sir, please send me the contact number of principal, sir, of Rupahi College in my WhatsApp. Yes, Dr. B.N. Patnaik, sir. Sir, please unmute yourself. Dr. B.N. Patnaik, sir. Yes, sir. Can you hear me, sir?
Hello.
Yes, sir. Now we can hear you, sir. Now.
Yeah, from the phone. I can connect now from the phone.
No problem, sir. We can hear you, sir. Now.
Okay.
Okay, sir. Thank you, sir. So I think we are about to start the program, and a very good evening to everybody, and welcome to this online invited talk on intellectual property rights, jointly organized by the IQAC of Rupahi College and IQAC of Kaliabor College. I am Dr. Virendra Pal, the librarian of Kaliabor College. And this is really a very great opportunity and a very great program on a very important topic. And among us, we have a very renowned and very expert in this field, Dr. Pranjal Kumar Fukan sir, the global mentor from the Indian Institute of Entrepreneurship, Guwahati. So I would like to welcome you, sir, in this platform. And before moving to the agenda, there is an announcement for the participants that we will share the feedback form at the last. So please fill up the feedback form. And if you have any questions, please write in the chat box. We will try to pick up your questions. And without wasting much time, now I'd like to invite the Honorable Principal Sir of Kaliabor College, Dr. Hidna Kumar Sulya sir, to provide his welcome address. Sir, please.
Good afternoon. Thank you, Dr. Birender, and welcome our co-host, Dr. Patnaik, Principal of Rupahi College. Welcome, Dr. Pranjal. He is the speaker and resource person of this talk. And welcome to all of the participants from both the colleges and other colleges also. Actually, we have very good opportunity here to hear some of the very dynamic and learned person, Pranjal Fukan. He is known to me, and his experience in industry professional with 25 years, more than 25 years in automation, telecommunication engineering, and petrochemical domain. He is now engaged in petrochemicals in Lepetkota, BCPL, Dibrugarh. He did his BTech and MBA in operation management in one of the accredited management teacher of AIMA New Delhi, associated with more than 30 international and national organizations with repute, research person of MSME, Department of Institute of Guwahati, IIE, Federation of Industries and Northeastern Region, Fine Art, Guwahati, and Institute of Scholars, members of Institution of Engineers, India, co-chair of ICC subcommittee on MSME and banking for Northeast India, and he has been awarded several national and international awards, receiving in the domain of supply chain, operations management, and entrepreneurship development. So, that is a personal point of view. So far, I know him. He's very dynamic and always requesting me to do some work in entrepreneurship development and getting our faculty and students for the startups, that is incubation center, etc., etc. He's a very dynamic person. If you look at his profile, you see that he is very dynamic person. And last month we have from our college we have did some seminar on this topic, intellectual property right, which is a very point of recent focus by the colleges and higher education institutions, especially in colleges. It is a recent topic. So during my conversation, as Dr. Patnaik told me that they are interested to have a talk or webinar on this topic. So he requested to contact some research person, and I immediately thought of him, Pranjal Phukon. He did a talk in Dibrugarh as during our principal council's biannual conference there, and also did some talk in our college last year during pandemic. So we have to use the pandemic period for a good academic exercises. So as a very learned person, we invited him to give his top lecture on this topic. Thank you. Welcome you all again. Thank you.
Thank you, sir. And really, it's a very great moment, and we are very proud moment for us to work under your guidance and leadership. Thank you again. Now, I'd like to invite the Honorable Principal, sir, of Rupahi College, Dr. B.N. Patnaik, sir. Sir, please kindly provide your welcome address, sir. Please unmute yourself. Sir, please unmute yourself. Principal, sir, Rupahi College. Yeah.
Am I audible? Yes.
Yes.
Thank you. I'm a bit, in an awkward position because of me, a couple of minutes were lost. I feel sorry for that. It's because of a technical snag in my laptop. Anyway, good afternoon to one and all. My dear friend, Dr. Hiranyakumar Solia, my next door neighbor and a great friend of mine, always extending his helping hand to me, Dr. Solia, and Dr. Pranjal Kumar Phukon, the resource person, and selected by Dr. Solia. I didn't have access to him until now, but I came into his contact in academic, that WhatsApp group. I used to come across some of his profile there. He's a man of great renown, known world over, is a global mentor, and he's from Institute of Entrepreneurship, Guwahati, Indian Institute of Entrepreneurship, Guwahati. So we are looking forward to hearing him this afternoon. And the two coordinators of IQAC, both from Kaliabor College and our Rupahi College, they have been instrumental in bringing this into reality. So I'm thankful to both of them, especially to my coordinator, Dr. Azizul Haq, who has been pinching me from the last 1 month to conduct such a program. And I'm thankful to him more because in the last 10 days has been able to conduct such programs in a series. So one on plagiarism, one on MOOCs, and this one is the third one on intellectual property rights. So very challenging topic for all the young upcoming teachers who want to have a strong foothold in the realm of higher education. It is intended for them. Rather, I would like to congratulate all the participants who have gathered today. It being so challenging a topic, many will wish away from discussing such a topic. So I'm grateful to all those participants who have voluntarily come forward to hear at least on intellectual property rights, which is going to say dominate for the next 50 years. That is my perception. So all the participants, resource person, and their coordinators of both the colleges, and my dear friend, Dr. Hiranyakumar Solia, I welcome you all. And I look forward to hearing from Dr. Pranjal Kumar Phukon with rapt attention, because it is also a new and challenging area for our college and for me as well. So on behalf of Rupahi College, I offer a hearty welcome to you all. Thank you. Over to Biren.
Thank you, sir. Thank you so much for your valuable words and valuable advices. And really, it's a very good jointly initiative of both the colleges. Thank you again for giving a very valuable input and time to us. Thank you very much. Now, we would like to move to the next agenda, and we have a very dynamic resource person with us today, the Honorable Dr. Pranjal Kumar Fukan, sir, the global mentor from the Indian Institute of Entrepreneurship, Guwahati. Sir, on behalf of both the colleges, I would like to request you to take this platform, and please go for your presentation, sir. Over to Dr. Pranjal Kumar Fukan, sir. Yes, I have seen two ID. I will make co-host in both the ID. Yes, sir. Can you hear me, sir?
Yes.
Okay, sir. Thank you, sir.
Yeah, thank you very much to our to Soliha sir and Patnaik sir, especially to Soliha sir for contacting me and giving me this opportunity. Actually, I was to discuss with Soliha sir not on phone but on messages a lot of time that now the time has come when, as per the new education policy, also there is lot of significance of intellectual property rights for the education institutions, not only for the industries, but also for the education institutions, because now the concept, as you are all knowing, that we should be going for creating jobs, not only for having jobs. So we should be in a position to create jobs. To create jobs for any startups, for any entrepreneurs, they need to have some ideas. So I was just discussing a lot of time with others and other platforms also that only idea is not enough. We have to commercialize those ideas, like from mind to market, a concept called mind to market. So whatever we are studying in our different courses or in our different streams, maybe in the graduate, undergraduate, postgraduate, whatsoever the case may be, we need to have a focus very systematically that how can we eliminate the pain points of the problem statements of the community. So today's session, see, IPR is a very big subject, and I'm also very much happy to say that many of the IPR attorneys across India and abroad are contacting me to have some joint exercise. Joint exercise means joint workshop of exercise with education institutions in India, specifically for Northeast, because we have a lot of universities and institutions of high caliber and high esteem, but we are still lacking focusing on the patenting. So that's the reason today's session is basically I'm giving as an overview of what is IPR, what are the paradigms or what are the sectors under IPRs, and how it is actually operating, and what are the historical chronologically how these things have evolved. And now presently the country, our country, India, is doing good. As per the records, we have 9 times more patents filed in the IPO, Indian Patent Office, under WIPO. So this stamina or this momentum should continue with all our education institutions in Northeast specifically, that the faculties and students should try to go for patenting their ideas, and they should not wait they should not wait for patenting or registration of the patents, because ultimately these will have two basic advantages. One is that if individual or the organization gets the patent, they will have a royalty. Means there's a system called royalty payment for you, whosoever is using your patents. And second one is that it will give the stature, it will improve the stature of yours. And thirdly, this patent will help the students and the group to get the funding without any much of the hassles, which you used to hear from the banks that they are not interested in giving you or lending you. Venture capitalists are not interested or not interested in lending you. But once you have this patent, they have no question to ask for lending you. Now I'm going to share my slide. Hope this slide is visible to all.
Yes, sir.
Okay. So this is in the slides, I am just putting the basics of what is IPR and how it is to be understood for applications. I'm not putting here how to go about the patent registrations and all this nitty-gritty, because Otherwise, it is a huge subject. It cannot be completed in a day. It has to be normally it is done by any institutions in a workshop type, like 4 days a week, or you can say 3 days a week. Something like a workshop is to happen in which the detailing of the registration process and how you'll go for the registration, who are involved in your registration, and what is the cost implications, how much time does it take, how it is get registered, whether should you go to India Patent Office or Australia Patent Office or other countries Patent Office. Before going there, what are the requirements you need to have, what are the clearances you need to have from the India Patent Office before applying to a patent office outside India. So next slide. This is already done. Now I will go through this. What is the concept of IPR? What is the history of IPR? What are the rights related to IPR? What are the branches of IPR? What are the emerging issues happening in IPR? What is the benefit of IPR, intellectual property rights for the individuals or the group or institutions or industries? And finally, the conclusion. So see, the intellectual property right, there are three basic words. One is intellectual, one is property, one is rights. So what does it mean? In technical term, intellectual means it is the relating to the intellect. Similarly, property means a thing or things belonging to someone. And rights means a moral or a legal entitlement to have or do something or prevent others from doing something. So I must tell you one thing here, that previously all the institutions are focused on like going for the copyrights. So presently this copywriting is not much of implication in comparison to patent, because copyrights can be infringed. Or suppose, for example, myself, if I'm going to take a copyright content of someone, I have to just know, I have to just refer in my paper. That is enough. But in lieu of that, the person who has got this copyright won't get anything. He will just get the recognition that okay, that person's copyright has been referred by some other writer in his case paper or article or something. But patent is not like that. You cannot just refer. You have to take the permission of the person who is owning that patent. Otherwise, a serious legal implication is there. And for that, he or she has to pay to that person who has got the patent. And that is also called a period is having defined called licensing. Means I can license my patent to someone, to some institute, some industries also. Or you can say transfer of technology, or technology transfer can also happen through patent if I have the patent for the particular subject. So these are the three basic definitions of intellectual property rights. Now, according to WIPO, that is World Intellectual Property Organization, the term intellectual property indicates the legal rights. It is something they call a legal ownership, which is resulting from the intellectual activity happening in the field of science, industry, literature, and art, etc. So the right of an inventor to derive economic benefits from this invention is the basic purpose. He should be benefited economically, commercially. The right which can be used for protecting different aspects of an invention work for multiple protections, outlined in Article 27 of the Universal Declaration of Human Rights. It is being outlined there. And IPR is largely a territorial rights. As I said, the rights are same, but you have to apply in your territory regions. Like Indians have to apply to IPO. They cannot just go and apply to any other country's patent office unless and until they get the NOC from that particular region's office, except for the copyright, which is global in nature. Now, IPR can be assigned, it can be gifted, it can be sold, it can be licensed like any other properties. So this is the history of IPR in India. It started in 1856 with the Act of Protection of Inventions. In 1948, trademark protection came into force. 57, Indian Copyright came into force. 1959, Indian Trade and Merchandise Marks Act came into force. 70, we adopted Indian Patent Act. In 98, Geographical Indication of Goods under Registration Protection Act came into force. In year 2000, the Semiconductor Integrated Circuits Layout Design Act has come into force. And in 2001, the Protection of Plant Varieties and Farmers' Right Act came into force. So this is the basic history of IPR, and it is continuously evolving. Now, what does this intellectual property right includes? These include the basic rights relating to literary, artistic, and scientific works. It relates to performance of performing artists, phonograms, and broadcast. It relates to inventions in all fields of human effort. It relates to all scientific discoveries, industrial designs, trademarks, service marks, commercial names, designations, and protection against unfair competition. So these are the rights under IPR, which is given to all citizens of this world. These are the basic branches of IPR, under which comes patent, copyrights, trademarks, designs, then you can say geographical indications and traditional knowledge, trades, secrets, confidential informations, and plant varieties. So under branches of IPR, if I say there are many big and small intellectual property law firms all over the world. Like in India, we have now lots of firms are there. Many are like patent agents, many are IPR attorneys. So like in India, US, Chicago, etc., providing qualitative help to all inventors and creators of the product. In India, basically, if I say specifically, IPR are safely protected. It's controlled by well-established statutory and judicial framework. Apart from that, there are many attorneys and law firms of IPRs in India in various states. So myself also is appearing for patent attorney, patent agent, because in India we have patent agents. So I'll be also appearing for this because it is a very lucrative subject, not only for the patent agents and IP attorney, for the law students, engineering students, science students, but also for those who are interested for getting themselves registered in patents, also for the faculties. I mean to say also beneficial for the faculties. So under Ministry of Commerce and Industry, a department of, you can say, industrial policy and promotion. So we have called a department called CGPDTM. This has a patent office. This has a trademarks registry. These have a geographical indication registry and plant information systems. So these, the copyright works, always works under the Ministry of HR. Human Resource Development now changed to Ministry of Education, Government of India. Then Protection of Plant, Varieties and Farmers' Rights Authority works under the Ministry of Agriculture, Government of India. So we have a very dedicated ministry and dedicated department, dedicated registry to check and control and have a qualitative approach towards patent rights to the individuals, groups, or institutions. So as I said, these are main forms of patents, so IPRs. Like I can say that patents, copyrights, trade secrets, and plant breeders' rights. So as I'm just repeating those, out of these four are basic terms of any education institutions. So individually, if I say first is copyright, so what does this copyright mean? It means it is an idea with an expression that comes and termed as copyright. So copyright is nothing, it is an idea with an expression. If I have an idea and I can express if I can express in written form my idea, like research papers or case papers, this can be copyright. So it is a right which is available for creating an ordinary literary or dramatic or musical or artistic work. I mean, any drama, literature, music, or artistic works, if an idea is there and it can be expressed, then it can come under the copyright. So in India, the Copyright Act 1957 has been amended in 83, 84, 92, 94, 99 is available. Registration can be done at any office at the Register of Copyrights in New Delhi, and nowadays it is available at the state capital also. And protection for the expression of an idea and not for the idea itself. See, only idea cannot be copyrighted. It has to have the expression in the idea itself. And the general rule is that copyright lasts for 60 years. Patents are not for this long term. Copyright is lasting for 60 years. So once you have got the copyright, it can be renewed after 61st year. So these are some of the copyrights. like for the literature, for the films, for the drama, musical, artistic, sound recordings, this all, because these all are the ideas with an expression. So these are comes under the purview of copyright, and this can be copyrighted. These are not covered under copyright. Only ideas, only facts, recipes, works lacking originality, like the phone book. Phone book means phone number book, or names, title, or short phrases. This cannot be copyrighted. Two case studies I thought I should share with you. One case study of 2003 in Bangalore. Bana Sankari police arrested 3 software engineers for copying the software from a company they were working for under Copyright Act. And in Chennai in 2000 February, pirated software worth rupees 1.11 crore. If I terms into US dollar, it is 253,200 was seized by the Chennai police, and total 6 employees were arrested, which includes the managing director of one of the outlet and proprietor of each of the outlets. So it should be known very clearly, once copyrighted or anything copyrighted under IPR are under the purview of legal action. Now comes the patents. So this is the most hot topic now globally, not only for the India, but for the globally. You have seen in COVID-19 cases also, due to this patent, availability of medicines, available raw material is getting stuck up, cost is going high. So this is only because of patent, because patent is the hot cake now. So I request all faculties and students to please get into this forum for getting registered under patents. Whatever idea you have, if it is innovative, if it has the invention involved in it, then it can be patented. And if you get it patented, it is good not only for yourself, for the institution, for the state, but also for the nation, for the country. So any patent is basically what? It is not only idea. That idea should have the innovative or different out-of-box thinking, value to the society, plus invention. So all 3 elements mix and makes patent. So it is a monopoly right. Please note this point. Granted by the state to exclude others from exploiting or using a particular invention. It is an exclusive right which is granted by a country to the owner of an invention to make, use, manufacture, and market the invention. Then patents provides incentives to individuals by recognizing their creativity, and incentives for encouraging inventions through monetary means by the investors if that particular individual or the group or the institution is interested for applying to this for the commercial purpose or opening an industry or starting a startup. And it also prevents direct copying of the inventions, and it makes competitors find other solutions. So these are the basic salient features of patent. So that's why everyone should try at their best to get their ideas innovated, ideated, and if it is found commercially viable, through many other forms. Like if you need, and I can give a solution to like how to come up an idea to the final prototyping and application to patent stage, then I'm always available. You just give me one chance. I will show you in details like what are the stages from ideation to patenting, including all the prototyping, scaling, and you can say like proof of business, how it can be processed in a very scientific method using design thinking. So that is a separate chapter. If both the colleges and Solihar sir and Patnaik sir are interested, then I can have one session of like not more than 1.5 hours for the students to understand like how to apply for the patents. So patents are basically granted for any inventions, innovations, process, or product of innovations and concept. So proof of concept, that's why I said these are requirements. Basically are it should be novel idea, it should have the inventiveness in the idea, the industrial application has to be there, usefulness, and disclosure statements needs to be there for every idea which can be ideated. So basic, there are 3 types of patents. One is called utility. It is used for useful devices and processors. Design patent is the appearance of any useful devices. Plant patents, which are like man-made plant varieties. These type of are the basic types of patent, which is mostly being used worldwide. These are the inventions which are not patentable. Please read this very carefully. Number one, anything which is contrary to public order or morality is not patentable. Only the mere discovery of a scientific principle, no, you won't get patent. You can get copyright, but you won't get patent. Mere discovery of any new property or new use, no. The mere arrangement or rearrangement or duplication of anything which is already there. A method of agriculture or horticulture is not patentable. Any process for the medicinal, surgical, curative, prophylactic, diagnostics, and therapeutic plants and animals in whole or any part thereof other than microorganisms, but including seeds, varieties, and species, and essentially biological processes for production or propagation of plants and animals are not patentable under Patent Act. Now comes trademark. So what is trademark? It is same, starts with an idea, but it has to have some quality involved in it, plus identity, a different identity, uniqueness. Then only you will get the trademark. So it can be a word, it can be a name, it can be a brand, it can be a symbol, label, etc., which are used by a company to create a unique identity for their products. And this can be registered by using this symbol TM with a R, with R encircle. This is valid for 7 years and renewable after expiry. In India, it is governed by Trade and Merchandise Marks Act 1958, which came into force on 25th November 1959. In patent, design patents are for 10 years and normal patents are for 20 years. So these are trademarks. You must have seen every time, like this Coca-Cola, where you will find the trademark as name, logo, the symbol. If I like, I am loving it, the Nike, the orange. These are all trademarks. So there are two types of trademarks. One is for the application. If it is application, that's called TM, and if used for the services, it's called SM. So TM means it is used for use applications to file for the products, and SM is basically for the services. So these are trademarks. So the example of trademarks. So trademarks are basically a distinctive sign that provides to the owner of the mark by ensuring that exclusive right to use it to identify their goods and services. So it includes all devices, brands, heading, label, ticket name, signature, word, letter, numerical, shape of the goods, packaging, combination of colors, and any combination thereof. So well-known associated trademarks, service marks, certification trademarks, and collective marks also comes under purview of trademarks. So terms of registered trademark is 10 years and renewable. To register a trademark, you have to have an appropriate national or regional trademark office. You have to approach there, and WIPO administrators and international relationship system for trademark. So obviously you don't have to go to WIPO, that is World International Patent Office. You can go to any appropriate national or regional trademark office and apply your trademarks there. So there's some of the example of trademarks. You are familiar with most of these trademarks you've seen. Mostly I put this for all the automobiles. So these are all trademarks. So which is basically to define the identity, specific identity of the particular manufacturer. Then comes trade secrets. So what are trade secrets? It is also part of IPR. The trade secrets are basically consisting of any invention, any idea. So idea can be trade secret. Though it is not patentable, only idea. It cannot be trademark, or it cannot be like used for copywriting also. But I can say only idea can be a trade secret. Survey methods, the methods you are doing your surveys, your manufacturing process can be a trade secret. Your experimental results, which is yet to be ideated, can be trade secret. Chemical formula, any recipe, which is very special, like recipe of cold drinks like Coca-Cola, Pepsi, they have these trade secrets under the recipe of their many pickle industry have the recipes, many other industries have the recipes. Any financial strategy you have, that is trade secret. Any client database, it is also trade secrets. So why these trade secrets are preferred? So because they are not patentable. So when they are not patentable, then they go for trade secrets, because all these things are not patentable. So they go for this. When there is not patentable, there's unlimited life, the cost is involved, and difficult to reverse engineer. Difficult, like recipe, it is really difficult to have a reverse engineering recipe, getting the feedback from the customers, and again doing all these R&D. So in that case, simply go for the trade secrets. Then comes industrial design. This is also part of IPR. So this is basically referring to any design, referring to of say 2-dimensional or 3-dimensional drawings. It has to have a purpose so that we can delineate, means we can differentiate on the basis of their shape, configuration, pattern, ornamentation, composition of lines and colors. It is basically applied to any article in 2D or 3D, in 2-dimensional or 3-dimensionals, or in both the forms, and adjust solely by the eye. So any industrial design is covered when it is found okay or found satisfactory based on the judgment by the eyesight. So it's applied to any article for the manufacturer. So the manufacturer normally go for industrial design for the changes in design of the products, outer design of the products to attract the customers. So what are the advantages? Advantage is basically the appearance and shape of the product is registered. Now your appearance and shape of product cannot be copied. Trademark is a label attached to the product. Appearance, like design, promotes marketability to the products, and registered design provides a legal cover so that no one can copy your design or your shape of the products and how it is get marketed. The criteria is basically novelty has to be there. It should be judged by the eye solely with respect to the external appearance of the finished article, and absolute novelty. There are two types of novelties. An absolute means not publicly known or used in India or elsewhere. So it is not presently being known anywhere in India or abroad. So that's why it is called absolute novelty. But normally people apply for the industrial design based on novelty. Two examples, like this is one design of mechanical cow for composting and design of aquafit set drills. So these are basically industrial design which are protected under IPR so that no one can copy this, no one can infringe on this. If they infringe or copy, then they will be penalized. Now comes the geographical indication. This is very known topics to everyone, like our muga, our tea, the many other things are now coming under geographical indications. So it is a sign that use of the goods and states that the given product originates is a given geographical area and possesses qualities or reputations due to that place of origin. So geographically, geographic indications may be used for a variety of products such as agriculture products. 3 examples I've given, like one for cheese. If I say that is Roquefort cheese is specifically produced in France, an olive oil called Tuscany is specific variety of olive oil, which is produced in specific regions in Italy. They are all GI indicators. Tea, Darjeeling tea, you know, and Assam tea, similarly. Wines and spirit like Scotch whiskey is also comes under geographical indications. So we know that it originated in Scotland. Now, what are the emerging issues in IPR? As Patnaik sir rightly said, it is a long impact, we're having a long impact of 50 years or more, because this is directly going to change our total concept of economy in coming years, not only economy, including commerce, engineering, and humanities and arts and everything, because the changing paradigm of the customer behavior due to disruptions and also digitizations is forcing us to go for this novelty and innovativeness. So intellectual property is going to play a very important role in increasingly broad range of areas, ranging from internet to healthcare. We have seen in COVID situation also, many things are coming under patents to nearly all aspects of science and technology, literature and arts. So there are following 2 topics. One is called biotechnology and its traditional knowledge are now being discussed at length at the international arena. So if we have a session specifically for how to go for patent registration, then these things can be covered, like why biotechnology and traditional knowledge are discussed at length nowadays all over the world under IPR regime. So these are the benefits of IPR in totality. If I say it is a good fence which makes good neighbors. If your fence are good around your house, then your neighbors will be happy with you. There will be no problem. Then filing first is a rule in IPR. Always file first. Provisional filing is first, then you go for the permanent means for final patent rights. It also encourages not only the students, not only the startups, but also faculties in industries towards innovation, product development, technical changes. It imposes a change in the mindset for the technical change. This gives a monetary gain, as I said, a royalty income for life to inventors, great inflows of technology, and reduces imports. Atmanirbhar Bharat. So conclusion is intellectual property rights reward creativity, human efforts, which fuel the progress of humankind. Understanding the country's IP rights and following the best practices can drastically reduce the risk of losing the company's intellectual property. Specifically speaking, for the MSMEs are facing this situation nowadays because of fund crisis, because they don't file for the patents. They don't have, they do have the ideas, but don't know how to ideate and how to file the patents, due to which they always have at the loser end. So Indian government has initiated various steps for intellectual property protections, and for this you must be doing that under the Startup and Digital India. If you go, there are a lot of schemes are there for this, and also government is providing up to 1 lakh to MSMEs free of cost for filing these patents at the India Patent Office. So with this, I'm closing my session and will be like requesting anyone, if any questions, then I can reply.
Thank you, sir. Really, it was a very good and very informative presentations. I hope participants will have some questions. Respected participants, please, if you have any questions, you may ask your questions writing in the Zoom chat box, or also you may ask your question directly to our honorable resource person by raising the hand in your Zoom application. আপোনালোকৰ যদি কিবা প্ৰশ্ন আছে আপোনালোকে ডাইৰেক্টলি দিব পাৰে আপোনালোকে ৰেজ হেণ্ড এটা ফিচাৰ্স আছে জুমত আপোনালোকে এটো জাস্ট ৰেজ হেণ্ড কৰি লওক
So first of all, I must tell you that first question the students should ask here, as I know that Soliha sir and his great initiatives, I'm always going through his messages towards entrepreneurship. But one thing I know, that every startup has a question that where I will get the funds. So one answer here, which I've said to you, that if you go for, there are two ways basically. One, you apply for patents. Provisional patent also is good for your pitch deck for funding, or otherwise you approach any of the incubation centers as mandated by the government, and you can get the right of using the patents of someone if the idea or if his product or if his patent is matching with your business idea. So that way also, if you can get his patent right for some time with a payment to that particular patent person who has got the patent, then also you have a lot of chance. Your chance grows to 90% to get the fund from not only from the banks but also from the venture capitalists and private investors. So these are the two options which I always say to people, that instead of going for the government schemes, you try these two. Either you file for the provisional patents, or you can ask for some other patents for your use. You can use that patent for your particular purpose. Because you know that everyone, because if I'm an investor, then I need to know that where is how safe is my money. But if you have the patent, then I'm very much clear that my money is very safe, because your idea has been validated by the qualitative people, by the quality people who are sitting in the IP office as per the international standards. So not only for the startups and businesses, but I think this is very much required for a glory of an individual, or for the glory of the state, glory of the country, because this will always provide inflows of idea generations. People will be more positive. They'll be more working in this COVID situation. The negativity, depression also will come down, because their mind will be anytime busy with the idea, and not only idea with novelty, idea for the ideations, how to have the prototyping, how to validate it, how to produce a proof of concepts. Many things are there. Only things, unfortunately for us also, it is quite scattered. So on the particular subject, actually, we should have this cohesive approach towards either for going for the patents or applying for the any patent rights from others on lease basis. So these are the very uses, two uses basically.
Fukon, what happened actually?
Yes, sir.
In some copyright, we mostly know that it is related to books, and we have to bring copyright. Or
Yes.
if it is published, or if it is ISBN or something else, it is already copyrighted. But in patent or trademark we know, but in patent and that is other part, what happened, we actually, due to our lack of awareness, we teachers or the students, we do not know what idea is to be patented, or how we can, what is the distinction between which idea we can go up to patent or which we should not carry. A lot of students, they have sometimes carry with some good idea, but we actually need more awareness among students, what idea we can carry to the patented position. It is a lack in education institution here. Sometimes we have some good ideas from students, even from teachers also, but we are due to awareness, lack of awareness, we are unable, or we're afraid that this could not be patented. This is not up to the mark of the patent. That is happening here from a point of view. And
No,
also in
yes, sir.
the last what happened, the number of patents applied cases from India is very less in comparison to other countries. As I have seen the that is the data. Yes, do you agree?
Sir, yes, very much. Because see, we are progressing at the rate of 9 times than earlier, but still we are lagging far behind than China, which are just our neighbor. And but we are improving upon. We are improving upon. Lots of emphasis are being placed to all the HEIs, higher education institutions, and this also comes into picture in NEP also. So your first question, sir, how to find that which idea can be patented is a very good question, and we have some scientific methods to clear out, to have the clarity to the students or anyone which idea is patentable. For this, we have approach called minimum 9 problem statements. So first of all, any idea has to be gets generated because the person or individual knows that this is the problem. So based on that only, he or she has got some idea. But it cannot be based on 1, 2, or 3 or 4 ideas for problem statement. The minimum global standard is he or she has to have 9 pain points recorded. Based on 9 pain points, he or she has to do the clustering of ideas. So these are very scientific methods now being developed everywhere. And most of the incubators, sir, if you inquire, including IITs and IIMs and any adult incubation centers, the first process is, first you have the 9 problem statements, then clustering of ideas. Based on the clustering of ideas, the person has to get a feedback from that particular customer segments or geography based on some simple questionnaires, whether the solutions or based on the clustering of ideas, those ideas can relieve or eliminate any of the pain points. And after that only you can select 1 or 2 ideas, and those 1 or 2 ideas is sufficient enough. And success rate is also good, like 90 to 90%, that those one of the single idea or one of the 2 ideas will get patented based on the prototyping, and finally we can go for the proof of concept and all these things. So there is some scientific method. That's why I said, I requested you also and to Patnaik sir also, that if you can have one session, just a 1.5 hour session, where I will just put up, today only I just got the definitions part. That day I can show some basic steps. And if your students try these steps, then I'm very much sure that at least 30 to 40% ideas can get to that position of filing of patents from both of you, the esteemed colleges.
In actually geographical indication also, we have lot of items and a lot of things here which are famous in Assam. We are not up to yet included in geographical indication. We have, I do not mention the names. We have already discussed with my fellow colleagues. There are 2-3 items which are could be geographical indicator.
indicator, yes.
Yes. There are a lot of, as example, Kajinemu is perhaps it is already geographical indication is there or not.
I
Muga
don't know,
is there.
but I have seen this Kagjinemo in some of the photos in South Korea and all. They're using this type of-
Yes, that is happening. Yes, we could not go for geographical indicator, and lot of things are there. But it should be
Only
given by application should be
our
given by
Halodi.
registered.
Halodi
Halodi,
also
yes.
got Halodi also taken by US.
You see what is happening.
Mm.
You see, due to a lack of our knowledge, and lot of things are there. And it is world-based Halodi is produced in Meghalaya, but they are
But
patented in
yeah,
USA.
they're patented. Yes.
What is a very unfortunate thing, and that still there are some remaining. So so far my knowledge concerned, it should be gives them by registered organization.
Yes,
Maybe
yes.
yes.
No, actually, GI is part of IPO, India Patent Office, which is in
Yes.
Guwahati also.
Yes.
I think for this you need to contact Ministry of Agriculture.
Yes. But there is it is not to private perhaps, it is from the registered society. It should be application should be as I have came to know.
That may be, but only thing is like it has to be clarified by the Ministry of Agriculture whether
Yes.
this should be go for GI, because GI also depends on the mass production stage. Like
Yes.
if it is getting some indication, then it gives whether it is probable for the commercialization like export business. If no,
Yes.
then I
Yes.
don't know whether they will giving because of this GI only for purpose of having a GI. That
Yes.
IPO won't allow. Maybe I don't, because most of the IPO GI cases, if you see, all are commercialized,
Yes.
like
But
tea
if,
or
can
muga,
a college
silk and
apply?
all.
Can a college
Sir?
apply? Can a college
College,
apply for this?
yeah, college can apply. College can apply because it have to apply directly to the IPO at Guwahati, regional IPO office at Guwahati
Yes, for GI.
or GI, because it is part of IPR. So all the 6 parameters, so anything comes, it has to go to India Patent Office.
Yes.
But
Thank
their application process is different.
Yes. And the process is different. That may be happen.
But
We can apply by at the college itself. We can apply.
yes,
Yes.
we can apply it.
Yes. Thank you. Now, earlier I known that it is from the registered organization like a Cytosabara or something else.
No, nothing, because it is being opened now. So except for the patent, except for the design patent, these are being
Yes.
said that it should go to incubation center if it is for the startup. But for
Yes.
existing industry MSME, they don't need to go to incubation. They just have to file directly to IP.
Yes.
Any education institution can also go directly file to IP. They don't need to route through incubation or something.
Yes.
It is only for funding purpose, nothing else.
Yes.
If you need some fund, then you have to approach some incubation center.
Yes. So thank you. It is actually it is recent, though it is a recent point of focus, but it is very necessary, which we have some, we find certainly sometimes we have some students who have a brilliant idea.
Yes,
we
sir,
have to nurture them up to patent level. Thank you very much.
Yeah, thank you.
Sir.
Thank you very much, sir.
No, sir, another question we are receiving from Dr. Dipanjali Shekhar, and she has asked this question that what is the difference between the published patent and the granted patent? In published patent, monopoly right will not be there, as she guessed. Then how we will be benefited and how it will affect on professional life, sir?
See, there is, as per my understanding, published patent or grant patent, actually patent is an exclusive right to the person who has filed. Okay. No patent is being published openly, because this is having a secret into it. If you go to any patent website also, you will just get the gist of the patent, not detail about the patent. For detail about the patent, you have to get the right from the person or institution or industry who has patented it. So there is nothing called published patent. It is not like copyrights. It is not the published patent or brand patent. So all patents are actually branded. All patents are exclusive. All patents have their exclusive legal rights across the world. So you are also requested that all the persons who are having ideas, don't disclose your ideas here and there. Don't disclose anything in your copyright, in your research paper also. Because I have approached one university in France. There they are providing PhD with patents. How? They have said your publication of your thesis is not mandatory because it may have something which is very much interest for the community, and this can be patented. If you just write it for the copyright, someone will copyright it and he will get the patent. So you can share your ideas and views to anyone, but don't disclose that secret. Then don't disclose secret unless and until your secret is get patented. That is the difference between idea and expression, and idea and expression plus novelty and invention. So that novelty and invention differentiates copyright from patents. So don't just disclose here and there your ideas. You can just disclose your idea, but don't discuss about the secret of how we are going to get it and what are the benefits. Benefits means commercial benefits you can discuss for the funding, but not those benefits which can be used by someone and he will apply for the patent. So it will take 18 months in India to apply for a patent and get the patent. So it is a long process. So that's the reason lots of benefits are associated with it. So I must say that the easiest way is to go to any patent office, go to any incubation centers and request for having the license from those patent person who have got the patents, and use that license for some time, make your business viable. And in the meantime, the patent for which you have applied for the license, you can modify it and apply as a new patent for yours. So that is also possible. A patent can have many patents, many patents. Okay, but only thing that basic subject of the patent cannot be given to you. So that's the reason, due to transparency using artificial intelligence, it is very difficult in patent for plagiarism. Means you cannot copy paste anything because everything is transparent now. All are AI enabled. So anyone across the world, any point, yes, I apply for the patent, you cannot reapply anywhere in the world. That will be shown in, and they will discard your request. So
Thank you, sir.
I think, yeah, don't please get confused with branded and published. You just go for the patents. I must say that you should not focus more on copyrights, focus more on patents. This is very beneficial for academics and industries.
Okay, sir. Thank you, sir. Very good advice you have given, not to disclose the ideas. And really, this will help all the participants. And direct questions we will take from Panigrai Prabir, sir. Sir, if you have questions, please ask your question directly to our resource person. Over to Panigrai Prabir, sir.
Yes, sir. Am I audible, sir?
Yes, sir. You're audible, sir. Please ask your question.
I'm directly asking to our whether the geographical modification food, whether that is under the domain of Patent Act or not.
Okay.
Which one, sir? Which one?
Sir, he's asking that whether the GI food is under the Patent Act or not.
Yes, I told you, no, it is all under IPR, intellectual property right, not under patent. They are part of the patent. IPR is like under IPR, I said patent is there, GI is there, trade secret is there, trademark is there, copyright is there, all are different. Application process is different, duration is different. But this all comes under Intellectual Property Right Act.
Thank you, sir. And really, it was a very nice season and very informative season. And really, I hope all the participants will be benefited. And thank you again, sir, for giving a very important time to us. And this will definitely motivate us to work in this area. So before concluding, I'd like to request the coordinator of IQAC from Rupahi College, Dr. Azizul Haq, sir, to offer the vote of thanks. Sir, please unmute yourself.
Am I audible?
Yeah, please.
Honorable Principal, Rupahi College, Dr. Patnaik, sir. Honorable Principal, Kaliabor College, Dr. Hirno Kumar Solia, sir. Honorable Research Person, Dr. Pranjal Kumar Fukan, Global Mentor, Indian Institute of Entrepreneurship, Guwahati. Respected Dr. Birendra Pal, Librarian, Kaliabor College. Dr. Abdul Jalil, Librarian, Rupahi College. participants from the Rupahi College and Kaliabor College and other parts of the country join this virtual event. At first, I offer my thanks on behalf of Rupahi College and Kaliabor College to Dr. Pranjal Kumar Fukan sir for his kind deliberation on the topic intellectual property rights. It's a really wonderful session, wonderful sharing. Sir has let us know about the IPR, which is very essential in this context for the young researchers. Next, I offer my thanks and gratitude to Dr. Hiranyo Kumar Solia sir and Dr. Gyan Patnaik sir for hosting this virtual event. I offer my thanks to Dr. Birender Pal for his kind hosting the virtual event. I offer my thanks to the participants of Kaliabor College and Rupahi College for participating in this event, and the participants of the various institutions who participate this event and make the event a grand success. Thank you all. Now I am concluding the vote of thanks.
Thank you, Dr. Azizul Haq sir. Thank you to you also for working hard for the making success of this webinar in a very systematic and very scientific way. Thank you again. And we are coming to the end of this program. And before winding up, again, I'd like to thank our honorable resource person for giving his very valuable time. And I request all the participants to fill out the feedback form, which is already available in the Zoom chat box. And for winding up, I request to switch on your camera and please come closer to the screen. We will take a group photo together and then we will wind up the program. Dear participants, apnar video to on korilo, just 30 seconds and then we will take group photo and then we'll wind up. Just give me 5 seconds. Still 3 images. Muhammad Asraf Ali sir, please on your camera. Fardis Begum ma'am, Azmal Haq sir, please switch on your camera. Yeah. So thank you. And with this, we are coming to the end of the program. Till then, stay safe, stay secure. And as a technical host, I declare today's program as end. Thank you very much.
Yeah, thank you very much.
It's our pleasure.